Hello and welcome to our legal topic presentation, Sexual Harassment, by Cindy, David, and Yumika. We'll first start with what sexual harassment means. Sexual harassment can mean harassment caused by a person's sex that make the harassed feel uncomfortable, unsafe, or humiliated. It can also be considered as any unwanted sexual advances, such as inappropriate comments that are sexual in nature, requests for sexual favors, and unwarranted physical touch, or even sexual assault. Anyone can be a victim of sexual harassment, regardless of gender, position, sexual orientation, or relationship in the workplace. Likewise, the predator can be anyone, including supervisors, managers, coworkers, and even clients. Under the Title VII of the Civil Rights Act of 1964, unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when one, submission to such conduct is made either explicitly or implicitly a term of condition of the individual's employment. Two, submission to or rejection of such conduct by the individuals is used as the basis for employment decisions affecting such individuals. Or three, such conduct has the purpose or effect of unreasonably interfering with the individual's work performance and creating an intimidating, hostile, or offensive work environment. This law states it is an unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise to discriminate against any individual with respect to their compensation, terms, conditions, or privileges of employment because of an individual's sex. Next, we'll discuss the types of sexual harassment. The first we'll discuss is quid pro quo, which is a Latin phrase that translates to something for something. This is usually a type of sexual harassment that refers to the action of exchanging sexual favors for something which can be a benefit or prevention of a determinant. Some examples of quid pro quo include threatening to terminate an opportunity or job if the victim declines sexual advances, keeping a promotion or pay raise at bay until the victim agrees to a sexual act, asking for sexual favors in exchange for a promotion, hiring, or other opportunities, or pressuring an employee to accept unwelcome sexual advances. The next type of sexual harassment we'll talk about is hostile work environment. And this is any incident or event that leads to general discomfort, humiliation, or fear of those involved. Some examples of a hostile work environment are sexual or offensive comments, sending inappropriate texts, memos, or images that are sexual or crude in nature, sexual innuendos in conversations, and unwarranted or unwelcome physical touch, such as rubbing, touching, or hugging. Now we will discuss a case, an event, and give a description from the employee's perspective. The court case we will discuss for this project is the Burlington Industries Inc. versus Elrith, 524 U.S. 742 1998. In this case, an employee claims she was constructively discharged because of unwanted, persistent sexual advances by her supervisor. While she lost no tangible job benefits because of his actions toward her and even had a promotion during her employment, the court held she could still bring a cause of action based on an hostile environment sexual harassment. Though the employer had a sexual harassment policy, the employee did not report the harassment until a few weeks after she left. In this case, we would assume that the employee's perspectives were burden of proof, reputation, and constructive discharge. In the case of the employee Kim Ellerth, she felt the sexual related comments made by her boss created a hostile work environment, which resulted in constructive discharge, where she believed the harassment was so unbearable that she needed to quit her job without going through the employer's sexual harassment complaint process. Kim believed that the boss's behavior was unacceptable, and even though she relayed this message to him by advising the behavior was unacceptable, or showing him by disconnecting calls or avoiding him and the behavior still continued. As a subordinate employee, she could have believed that no one would believe her, which would burden her with the burden of others believing her story or having to prove her story. By showing that the collective evidence could be judged as harassment by any other reasonable person. There could have also been the perspective of her reputation. What if she told and they did not believe her? Or what if her story got out? What about the shame and embarrassment she may feel at not being able to stop these unwarranted behaviors herself? Next, we'll discuss this case and event and give a description from the employer's perspective. From the employer's perspective on the court case Burlington Industry versus Elred, the employer, Burlington Industries, had a sexual harassment policy, which the employee did not report the harassment until a few weeks after she left. While the court said the employee could still bring the sexual harassment action, in cases such as this, where there is no loss of tangible job benefits, the employer could use as an affirmative defense the existence of procedures for reporting and handling sexual harassment complaints and Kim's failure to use them. The employer perspective in this case could be determining the truth of the allegations, reputations and financial impacts, and policies to prevent. So while the employer could use an affirmative defense, which is the existence of procedures for reporting and handling sexual harassment complaints, and Kim's failure to use them to win this case, they are also burdened with determining the truth of the allegations. While they may be able to win the case since the employee did not report it in this case, and there is no official act that the employer was made aware of when Kim left, thus eliminating the employee's knowledge of the harassment, the employer needs to ensure the employees are comfortable with reporting and have a means to do so. Also, there is the perception of the employer's reputation if sexual harassment claims do surface. What if Kim's allegations are true and there are other employees that are being subjected to this unwanted sexual behavior? This could later result in future court cases that could ruin the company's reputation and have severe financial implications. Lastly, it is important that the employer ensures that they have a strong sexual harassment policy that will prevent harassment of any kind and effective training, monitoring, and reporting for the sexual harassment going forward. While Kim did not report her harassment, there could have been something in the training or the ways that she was allowed to report the sexual harassment that prevented her from doing so, which could cause issues moving forward. The employer needs to make sure that their policies are in fact able to prevent any future sexual harassment cases.
There are generally two main areas of sexual harassment law that are applied to cases: hostile environment and quid pro quo, as covered by Cindy earlier. In the case of Burlington Industries Incorporated versus Ellerth, the employee Kimberly Ellerth was filing the sexual harassment suit against her place of employment, Burlington Incorporated, on the grounds of a hostile work environment. To be considered hostile environment sexual harassment, the following conditions need to be met. The acts must be unwelcome by the person being harassed. The harassment needs to be targeted by gender. The severity of the harassment should be significant enough to create an abusive environment at work. There are terms, conditions, or privileges of the employment that are being withheld or affected by the harassment. And the employer had to have some form of knowledge about this sexually hostile work environment and did not take appropriate action or take action promptly enough. While it is made clear that the first four conditions are met in this case, the final is not because Ellis never reported the ongoing sexually hostile work environment to her employer, nor did she allege any loss of tangible work benefits or promotions. The criteria is then met, allowing Burlington Incorporated the right to be able to raise an affirmative defense to liability. The criteria being that the employer exercised reasonable care to prevent and correct promptly any sexually harassing behavior, and that the plaintiff employee unreasonably failed to take advantage of any preventative or corrective opportunities provided by the employer or to avoid harm otherwise. This affirmative defense essentially means that the plaintiff, Ellerth, must prove with reasonable evidence that Burlington Incorporated is subject to vicarious liability for the supervisor Slowick's actions, and if they in fact created a sexually hostile work environment. In order to see if Burlington Incorporated should be subject to vicarious liability for Slowick's actions, it is important that we understand what vicarious liability is and how it applies to this case. Vicarious liability is when the employer is responsible for the harm or damages caused by an employee to another person or entity. In an employer-employee relationship, vicarious liability can also include circumstances where the business or employer is responsible for the actions of a supervising employee that affect the employees under their supervision. Slowick did create a sexually hostile work environment by making repeated, undesired sexual advances and comments towards Ellerth, and Slowick's behavior absolutely warranted being labeled as abusive. Slowick's abuse even hindered Ellerth's ability to effectively do her job. And since tangible employment action taken by the supervisor becomes, for Title VII purposes, the act of the employer, Slowick's actions supersede Burlington Incorporated's lack of knowledge of the sexually hostile work environment due to Ellerth's failure to report the incidents. It is also worth mentioning that Ellerth's primary reason for not reporting the conduct of Slowick is because she would have been required to file her complaints to Slowick himself and rely on him to accurately relay the behavior to upper management. For these reasons, Burlington Incorporated does assume vicarious liability in this case for the conduct of Slowick.
So, what was the result in this case? In the case of Burlington Industries Inc. versus Elworth, plaintiff Kimberly Eldred quit her job as a salesperson in one of Burlington's division in Chicago, Illinois, allegedly because she had been subjected to constant sexual harassment by one of her supervisors, Ted Slowick. Slowick was a mid-level manager who had authority to hire and promote employees, subject to higher approval, but was not considered a policy maker. Against a background of repeated boorish and offensive remarks and gestures allegedly made by Slowick, Elworth places particular emphasis on three incidents where Slowick's comments could be construed as threats to deny her tangible job benefits. Elworth refused all of Slowick's advances, yet suffered no tangible retaliation and was, in fact, promoted once. Moreover, she never informed anyone in authority about Slowick's conduct, despite knowing Burlington had a policy against sexual harassment. In filing this lawsuit, Elworth alleged Burlington engaged in sexual harassment and forced her constructive discharged in violation of Title VII of the Civil Rights Act of 1964. The district court granted Burlington's summary judgment. The Seventh Circuit in Bank reversed a decision that produced 8 separate opinions and no consensus for controlling rationale. Among other things, those opinions focused on whether Ellard's claims could be categorized as one of quid pro quo harassment and on whether the standard for an employee's liability on such a claim should be vicarious liability or negligence. Under the Title VII, an employee who refuses the unwelcomed and threatening sexual advances of a supervisor yet suffers no adverse, tangible job consequences may recover against the employer without showing the employer is negligent or otherwise at fault for the supervisor's actions, but the employer may impose an affirmative defense. The court assumes an important premise yet to be established. A tier of fact could find that Slowick's remarks numerous threats to retaliate against Elworth if she denied some sexual liberties. The threats, however, were not carried out. Cases based on carried out threats are referred to as quid pro quo cases, as distinct from bothersome attentions or sexual remarks sufficient to create a hostile work environment. Those two terms do not appear in Title VII, which forbid only discrimination against an individual with respect to his or her terms or conditions of employment because of sex. Given the court's explanation that the labels quid pro quo and hostile work environment are not controlling for the employer liability purposes, Elrith should have an adequate opportunity on remand to prove she has a claim which would result in vicarious liability. Although she has not alleged she suffered a tangible employment action at Slowick's hand, which would deprive Burlington of the affirmative defense, this is not dispositive. In light of the court's decision, Burlington is still subject to vicarious liability for Slowick's activity, but should have an opportunity to assert and prove the affirmative defense. What could have been done differently to ensure a more beneficial result? Empty threats to affect someone's career still make for an hostile environment violation, and thus are in violation of the law and can leave an unknowing employer liable. If Elworth would have spoken up on the matter, it could have been addressed in a different manner. What is meant by beneficial? It's in the employer's best interest to create a work environment that discourages harassment and encourages employees to treat each other with respect. You can achieve this by having a clear policy towards harassment, a receptive attitude towards complaints, and regular harassment prevention training. Remember, employers are responsible for ensuring that their work environment is free from harassment. Employers can be held liable for an incident even if they had no prior knowledge of the incident. You must take action promptly upon receiving reports of harassment. Ignoring such reports can cause low employee morale, increase absenteeism, damage your reputation, and increase dissatisfaction in your workforce.